right, it is 6 o'clock. I will call the meeting to order. And Ed, will you please lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Ed, I appreciate that. You're closest to the flag.
That's right.
All right, so on the agenda before you, everybody take a quick look at it. Let me know if you have any changes or I'll entertain a motion to approve.
Misspelled bylaw.
Oh, typo in the bylaw spelling, okay, thank you.
Yeah, EY or whatever it is.
Okay. All right. Any other changes? Everybody good with the agenda? Okay, so do I have a motion?
Motion.
Okay, do I have a second?
Second.
Okay, any other discussion? All those in favor?
Aye.
All right, carries 4-0. So we will operate from the agenda before you. Everyone should have had an opportunity to review the minutes from the May 7th meeting, the May 28th meeting, and the July 29th special called meeting. Did everyone have a chance to review those minutes? Okay. And is there any corrections or revisions anyone like to suggest? Or do I have a motion to approve each one of those meeting minutes?
Make a motion to approve the minutes of May 7th, May 28th, both regular meetings, and July 29th, the specially called meeting.
Do I have a second?
Second.
Okay. Any additional discussion? All those in favor?
Aye.
Okay, carries 4-0. Thank you.
July, that was 29th.
That was that T-Splosh meeting that we had to call the election for the T-Splosh.
To put it on the November ballot.
Is there minutes for it?
I just handed them to you. They were in that email, but there was about 6 different attachments in that email.
Okay.
All right. Next item on the agenda is old business, and it is the final draft of the bylaws, which is located behind the agenda in your binder. I made some obviously suggested changes, and then I went ahead and submitted those to Stacy. Stacy took from the minutes what was to be amended as well to the bylaws and then forwarded on to our attorney, and this is what you have in front of you now. If these are approved tonight, then they would get put out for public comment, and we would actually adopt them at the September meeting, because we have a requirement to let them be out for public response prior to fully adopting them. So, everyone will.
So can I ask a question? Go ahead.
You go ahead.
The document that was attached and the document that I'm looking at now, was it just typos that were edited or any changes that need to be pointed out?
Well, that's what we're gonna discuss tonight. I know Becky found some typos, that she wanted me to, address so that we can get changed. And then I think there's a couple other things that Jackie wants, stricken through and not put in there. So that's what we're discussing now.
Okay.
All right.
Okay,
So you go ahead, Becky.
this typo on, first page, Article 2, the second line, where it says election superintendent of Pickens County, the superintendent should be capitalized because on the second page on Article 5, there's an election superintendent where the election superintendent is capitalized. So both of those should be either both capitalized or not. On Article 9, which is on page 3, typographical error, the third line down, and says what to cause an intentional violation. It should be not and, should be and. Attempts to
Yeah,
cause
okay, I see it.
and intentional violation.
Third line between cause and intentional.
And then on Article 10, the second paragraph on the last line, scheduled to close on election days, not closed. Should be
Yeah.
closed.
Actually, that was one of the paragraphs that I was going to discuss with you all. I don't know if we need to even have that in there or in the detail that it is.
Okay.
That was part of the reason we were making amendments to the bylaws originally, was because there were a few things that were getting us a little, I think, too pigeonholed specific about things. So, I mean, I think that, and like with our training, we have had it where, depending on the budget allowing, several will attend virtual versus several attending in person. So we do it on a rotating basis, so I don't know if we even need, I guess I'm just asking if there is much of a need for the entirety of paragraph 2 under that.
Well, I don't know. I haven't attended any annual training provided by the Secretary of State,
And nor have I, but I've done virtual.
except when I went to
Right,
the,
and that's why I'm saying
That's
I
the
don't,
conference
Yeah,
that we
conference
go
is
to and we do it on a rotating basis. If we do any new board members that come in first, and then we rotate the other board members, and we normally do 2 at a time.
so that's why I don't know if we even want that in there any longer. We know that that's a procedure, obviously, that we're doing, but I don't know if it's necessary to be in the bylaw.
So let me ask the question then. If you're a new person coming in and you're referring to the bylaws, how do you know that?
Valid question. But I don't want people to ever automatically think that they are attending, because again, it's a budget constraint type thing too.
Right.
So that if we need to leave it in there, then we might want to look at the wording of it, I guess is what I'm trying to say. Because attend could be either virtual or in person, I guess, or do we need to specify virtual or in person and just clean that up so that they know? I don't want everyone to just think they're coming on board and then they're gonna go to a training if in the budget, we don't have the money to send everybody to in person, because there's a lot of expense with meals, travel, hotel, plus the conference registration that may not be budgeted if we had 3 new people on the board. So,
But this is just a recommendation. It doesn't say that everybody shall.
Okay.
It just says it's
Yeah, it is
recommended.
okay,
I mean,
But I think just,
so I mean, I would defer to our attorney and see what
I
she
mean, it's up
says,
to you,
but
You
it's
don't- it
just
does
a
not have to be in the
recommendation.
bylaws.
yeah,
So, or you need to change it to recommended to watch the, webinar sponsored by the
you could
Secretary of
just put it to
State, or
live
put nothing in there, or,
virtual. I think you probably covered.
I thought
it.
that's what it
or just even say it's recommended that board members keep up to date with
Yeah.
webinars or continuing education sponsored by the Secretary of State or something.
yeah,
Yeah, and I like the continuing education through the Secretary of State, because I mean, it at least it doesn't limit it to the annual conferences. It can be, any form. The other thing in that paragraph in Article 10, paragraph 2, that I think we need to look at rewording is that board members may observe or assist with county polling locations on election days and be present at the elections office. But up there right above that, they must attend at least one training. They have to attend training for every election that they work. So I think we just need to possibly reword that, so,
yeah, if you're gonna be covering lunches, like in November, early vote, you have to go through the training again, even though we've all already done it once
Yeah,
this year. So, so that whole paragraph, I think, does need a little bit of a,
rewording just a
yeah,
little
or
bit.
like I say, or it gets, removed, one or the other. Because the way it reads is just, there's a little bit, it's pigeonholing a few too many things and leaves her a little bit of question, I think.
And our board compensation policy, it states that they have to go through training in order to work, and then they get paid for, one day of working. So I think we can compare our compensation policy and along with this and change the verbiage just a little bit to meet the needs of all of that.
Okay. That sounds good. All right, Becky, did you have anything else? Terry, Ed, anything else as far as the
Well,
bylaws?
I mean, I was trying to compare it to what we had talked about at the board meeting, the prior board meeting. I mean, on Article 7 about meetings, we had discussed about adding in the very first sentence, the board shall hold regular the board shall hold regular monthly meetings as necessary to conduct business, to add that.
Thank you.
Right.
Mhm.
And then to say, said meetings shall be held, and maybe this is, just saying, let's see here. Oh, yeah, and we said, we did say the first Tuesday of each month at 6:30, which we don't even do. And just say, said meeting shall be held on a date and time as advertised. We talked about changing it to that.
Mhm.
Okay, so a little bit more than where it says all meetings shall be advertised, or just shall hold regular monthly meetings as necessary at a date and time advertised.
And then under the employees section, which is now Article 9, we had said we would add a sentence that says the board, we say the board shall hire and supervise the election, but to say that then the election supervisor hires the staff. But maybe we don't need that in there, I don't know.
Well, I think I may have taken something out because I didn't want to end up crossing with the HR policy. So I don't know if we can.
Yeah, because I remember putting
Because
something
we
in
are
there.
still, or you're bound by
Mhm.
Pickens County's HR policy. And so I didn't want to,
And that was part of the reason we needed to take out what was in
Yeah,
there, was
so-
because
I didn't want to cross with that because I know too, they're also going through some of their policy reviews, but we can put like a general statement, maybe following Forsyth County governments.
Pickens County.
Or, oh my God.
I know, it's
I
okay.
spent 5.5 hours at a Forsyth County Elections Board meeting today.
I promise we're not gonna keep you that long. 5.5 hours, no,
Yes.
we need dinner somewhere.
They're, like, you can hire staff pursuant to the Pickens County government HR policy.
However, we need
Yeah.
to like tidy that up and put that in there so that gives Stacy the authority to do it, but that we follow, not just Stacy, but whoever's the election supervisor, I'm sorry. We did say that we were gonna add the public policy or participation policy, sorry, I missed that. And we did, I see that's in there now at article number 8. Does this reflect what we have in ours? Is there?
To an extent, it has the 30 minutes with 5 minutes each. I did add, and if you wanna take this out, some of the things, I mentioned some of the case law that's come out where the court doesn't like telling you to not direct comments to a particular individual. And you think about it this way, because generally if someone says something great about a board member, they'll let that happen. But if they start criticizing a board member, they tend to shut it down. So it starts leading to where you're picking and choosing because you want to hear about the good and the bad. And I've added in basically what courts have said. You don't want to be, people have to be allowed to speak both critical and positive. But if they're disrupting the meeting, you can shut that down if they're actually causing a disruption. I did add in too that they should limit discussion topics to election related or issues
Right,
that are
I
in the
saw
front of
that.
the board, just, and that, it's not a time to go back and forth,
Right.
but you may ask questions or refer staff or ask staff to follow up. so that you could provide an answer to the person. And then I also just put, I mean, you don't have, at least since I've been here, a long line of people speaking, but just in case, that Pickens County residents can be given priority over non-Pickens County residents.
Okay. So can I ask one last question, Rick, and I'll defer to you. So what we have that we have typically read for public participation, does this now change to what we have in the bylaws?
Yeah, so instead of that policy,
Okay.
we're putting it in the bylaw. It doesn't have to be in the bylaws, but I believe that was the direction from the last meeting to put it in the bylaws. I put it under meetings because I just felt like that was the better place to flow with it being right under meetings.
Correct. So then when we do it, if we had comment or participation, then we would have
If you wanted to
to.
then take this
this.
and put it in a separate sheet for you to read, or
Okay.
you know, you can do that.
Okay, perfect, thank you. Go ahead, Rick, I'm sorry.
I was just saying, who makes a determination of whether you're a resident or non-resident before the meeting to go if you have a long line of people?
You can just ask Pickens County residents first,
There you
and, yeah.
Okay.
And usually, I mean, you don't have to, but, usually boards will ask people to state their name and, their address or their residence to be put into the minutes.
And other boards on the sign-in sheet asked anyone who's wanting to speak to list their name, phone number, and address. And that might be something that we'll need to amend our sign-in sheet to do, so that way we can look at it and you know, take Pickens residents priority over anyone else that signs up to speak.
Alright,
Just one very minor thing. Article 7, the third line, meetings shall be advertised in the legal organ of Pickens County. That's so archaic, isn't it? It's not.
There's only one legal organ in the county, and that's the newspaper, but we do get it out to the other media outlets as well.
Okay.
the progress is the only one that we're
And we're
legally.
required
Yeah.
legally to put it in the legal organ.
So going back to the Article 8 about the public comments, I mean, I guess I'm looking at our old policy and it says the board will not respond to comments or questions posed by citizens in their presentations, but will take those comments and questions under advisement. I mean, I think that's,
You wanna leave that in there?
I do. I mean, I
Okay.
think it's more directive than that we won't have a time for discussion and between board members and speaker.
Okay.
I mean,
So go to more to that language that was before?
At least that particular bullet in the participation, yeah, if we could just include that bullet in some form or fashion, however we need to word it,
Okay.
that would be. All right, anyone else, any other? So given these changes procedurally, we would have to wait again until the September meeting to vote on them, or?
Well, if everyone's good with it, and depends if you wanna review it or not.
Right.
We can make the changes and go ahead and advertise it, and as long as if it's advertised for at least a week,
We can do it
You
all,
vote on it then, but we can go ahead and advertise like the draft changes, but if you do want to make additional changes at the meeting, then we would need to postpone it again.
okay. So I guess that's where we're at then, that we would go ahead and have these changes, or have the things updated that we discussed here tonight. And then we could get it back and still publish it for the required time frame, and then vote to
Yeah.
a final, accept everything at the
Right.
September
So
meeting.
if you wanna accept as written, the one that was advertised, there's no need to
Okay,
postpone it again.
okay.
And if the state election board throws something else at us here, can we just append this?
Yeah, I don't even, I was hoping to try and catch up with what they did today, but
Stacy was watching part of it too.
I know,
so-
I was trying to Google in my car when I got in the parking lot, cause I was in meetings all day and I was like, I don't know what they did.
Right.
I just didn't want to approve and have to go right back and do something
Yeah,
else.
I had a really brief time to watch it and it was a public comment section, so it wasn't in the meat of the meeting.
Okay.
So one more thing on Article 10, under the section for election supervisor, like Becky had pointed out in some other articles, there's some typos, so it says election supervisor instead of elections with an S in a couple of the sentences, so maybe, you can just spell check that and make sure it's consistent
Yeah.
throughout the
And I think
document.
This
And
went
the other
from a
thing that to me
PDF
would
to
be,
Word.
it would be really helpful is to have it redlined so we can see the changes
And that-
easily instead of trying to figure it out ourselves.
Did you have some comments?
No, I was gonna look, the thing that you just said is that, it'd be very difficult to try to remember what we actually all agreed to wanna make the change. And if there's a way to identify it in the next document, we can ensure that the changes were made and it will be a lot faster.
Sounds good. I should have read that. I think it was a PDF version. I don't
Yeah, it
know.
was originally a PDF, so we had to
Yeah.
convert the PDF to Word.
Yeah. It was a couple of step process
Or it
to
was
get
a
it to.
scan, I don't even think it was a PDF, it was a scan or a hard copy that was PDF
And then we
and then
converted it.
converted.
Yeah. But we will.
Use PDF more for presentations, is what you using the PDF for, or just happen to be the document?
Well,
it
she
was
just inherited a hard
Yeah.
copy.
Mhm.
Okay.
Yeah. There was, the original board
Yeah.
did this and she just received whatever they created, so.
I just don't use a lot of PDFs anymore.
All right, so we will, I guess, be tabling that till, that, what we need to do is
Yeah,
table
well,
it?
we'll go ahead and, we can go ahead and make the changes and publish it, and we'll publish it as like a draft.
Okay,
So.
perfect, all right. And then we can do the final vote if everything is acceptable at the September meeting. Okay. All right. Moving on to the next item on the agenda is new business. And here you go, you're up, Karen. Let's hear
This is
about
voter
the
challenge.
voter challenge policy.
Okay, well, have y'all had any before?
We have not.
We have not.
Okay, so I'll give you a brief summary, and then I know Stacy has put in here samples from, who did you put in here?
Fulton County and Forsyth
Is this
County.
Fulton County?
That-
Forsyth.
I also put in some information that the
Okay.
ACLU sent out to me that kind of just gives you a little bit more definition about the verbiage of voter challenges, just for you. We don't have to go over it, but just for you to understand the terminology if you're not used to reading anything about voter challenges.
So this is Fulton's, and then Gwinnett actually has a pretty good one too, and then the Forsyth one, which they actually voted to amend today. So that would be different than what's in here, but. So as you know, there are lots of different ways for list maintenance. There is sort of what we call like systematic list maintenance, which uses national change of address data, the ERIC system, which I forget what that stands for. I think about 25 states participate, and then based on that, so they take the national change of address data, they then ask the counties to send out confirmation notices to people to confirm whether or not they're still at that address. It doesn't remove people from the rolls right away, it may move them into inactive, and then, so that's one way. Then you also, as a board, have the authority to continue, like, the list is always changing. People are moving in and out of counties, they submit, Stacy will get notifications of felons or obituaries, and those will get removed, so it's always a fluid document.
Fair enough.
So one of the other ways Georgia law allows, and it just, I hate to say the word popular, it became used more after the 2020 election, is citizen voter challenges. So there's basically two types in the Georgia law. It got amended somewhat in Senate Bill 202 back in 2021. It got amended again this past session in Senate Bill 189. Most of it hasn't changed, but what it allows, if anyone in Pickens County, they can challenge someone's name who's on the Pickens County roll, that they believe that person should not be on the Pickens County roll anymore.
Okay.
So the one thing though that you have to weigh in on this, because there's also federal law, the National Voting Rights Act, and there's also case law, and then there's also sort of put into Senate Bill 189 now, is just changing your address on the post office national change of address data is not sufficient to uphold a voter challenge under these two laws. So that's not enough in and of itself. Those people automatically will get the letters generated by the Secretary of State when they send the name, and you just sent some out, I think in June or July. They do that periodically. They don't do that within 90 days of an election because of the National Voting Rights Act, so those had to go out before August 7th. But you can use, so someone could bring a challenge, it has to be in writing, you have to specify the basis for each challenge for the voters. It's Pickens County, a resident can only bring in Pickens County voters, so it can be, so for example, the person that we had in Forsyth County today, she had researched, I think she started with national change of address data, but then she researched home sales, those properties where people moved, and looked to see if they sold their home in Forsyth County. She looked at the Georgia voter history to see when they last voted. And then based on where they were moving to, she looked to see if they registered in the other state and brought their registration in the other state and showed if they purchased a home there, if they had homestead there. She even on some of them included social media. So, and she had that for each person on the list. When someone brings voter challenges, you're sort of sitting a little bit in a quasi-judicial role, in that you're weighing the evidence that they bring. So this is like one bucket, one method of cleaning up the rolls, and when someone does bring this method, they have the responsibility to show you why they believe these people that they're bringing forward should be on the registration rolls, and you're weighing the evidence that they bring you.
And you mean us as a board?
As a board, so you would, vote on it, it would require 3 of you to uphold the challenge,
Okay.
essentially. There are 2 types of challenges. So one, I just call it a 230, it's under OCGA 21-230. I don't wanna say that's the easier of the challenge, but it's a little bit different. So in that one, you are saying, I don't think this person should be on the roll for the upcoming election. It only lasts for one election. It does not remove the person from the roll at all. So then the standard is lower, so it's a probable, when it comes before you, it's a probable cause standard.
This
So
is
it
230.
Yeah, 230. And the way the statute is worded, it just says the board shall immediately consider 230 challenges. Does not define immediately.
Great.
If it's, and that's what, like in the policies, that's a helpful thing. So like in Forsyth County's policy, it says if it comes within this many days of the next regularly scheduled meeting, it'll get added to that meeting. If it comes in after that date, it'll be added to the next meeting.
And that's in the
Their-
sample that
That's
we
in their
have.
policy,
Okay.
and I don't know what Fulton's has, but they probably address that also. It's essentially whether a reasonable person would believe that this person shouldn't be on the roll, on the Pickens County roll.
Okay.
But again, this kind of challenge doesn't remove them from the roll. I say flags them, I don't know if that's the proper word. Because whatever Stacy, if you uphold a challenge, Stacy on the back end will be flagging them or whatever in Jarvis, sorry. In Jarvis to, as they come in to vote, it'll show up, you've been challenged.
Okay.
They can ask, so when the person comes with a 2:30, you don't have to notify the voter yet that they've been challenged.
Oh.
If you uphold the challenge, they receive a notice. They can ask for a hearing before the board, they can confirm or change their registration at that time. If they come in to vote, what we have done, and the Secretary of State has started recommending this, there's like it's a one-page affirmation form. So when they come in to vote and they say, the poll worker sees, however it's noted.
Yeah.
You can sign this affirmation form where you are affirming and swearing that this is your residence. And if they sign that, the challenge goes away and they can vote per normal. I have seen where voters come in and they still want to vote, but they don't want to sign that form. If they do that, you can give them a provisional ballot.
Okay.
And then they need to come to that certification meeting and explain to the board why they didn't want to sign it and why they feel that they should still be allowed to cast the Pickens County ballot. And you would then at that point vote whether to accept their ballot or not. Yes.
So can I ask you a question about
Yes.
that? I don't wanna interrupt your train of thought, but okay, so you said they would come to the certification, so, I mean, now, correct me if I'm wrong, Stace, but on election night,
Yeah.
we look at those provisional. Well, no, I'm
No,
sorry,
no,
I said that wrong. It's a couple days later,
Mhm.
We have
because
to do all
Stacy
the
has to do
legwork.
all the research first, then we have a panel that looks at them.
Yeah.
So would it be at that panel meeting, or is it at the election board meeting when we vote to certify the election?
It's whenever you are voting to review provisional ballots. Do y'all do
So
that?
it'd be
at your
the panel.
certification?
It would
We
be at
did
the
that before
panel.
the certification.
Oh, okay, sorry.
Okay.
So whichever meeting it is that you're reviewing the provisional ballots.
Okay. Alright.
And we've had
This is 2:30, right?
under 2:30.
So when you say they're flagged,
Mm-hmm.
and then after the election, the flag is removed
flag
and they stay
goes
right
away.
back on it like nothing ever
Yes,
happened.
exactly.
Which I highlighted this, that makes no sense to me. If I'm gonna flag you, have all the meetings and conversations, then after the election, the flag is removed.
Now, the board can then move later and do a 229 challenge, which we will also discuss. But
The board can?
yes, but after the election.
Okay.
To hold a 229 hearing after the election. So, but until then, it would go back to normal. And I've had someone, they did accept her ballot. We had someone who indicated they were homeless and her registration showed, she had put, wherever she tended to stay, and she was like, I'm still homeless, but now I'm staying here. They did vote to accept her ballot, so it's something that would be up to the board depending, but she didn't want to sign that statement, so, but that's the kind of thing when you do review a provisional ballot that you would look at. So, okay, go ahead.
It's up to the challenger to decide which one they're gonna go with
Yes.
instead of the board.
So the challenger decides whether it's
When
29 or
they-
30?
Yeah.
They have
But-
to lay that out.
Yeah, so the challenger, when they first submit it, they specify, I'm bringing a 230 challenge or I'm bringing a 229 challenge. If they bring a 230 challenge and the person does not, never shows up at the polls, the board can move on its own to then convert that into a 229 challenge. So part of the Senate Bill 189, which is new, is that if anyone does bring a 230 challenge, within none can be challenged within 45 days of the election. So I forgot what that date is. I think it's September 19th or something. So if they want to bring them, they have to bring them before that date.
Okay.
So that was part of what the legislature said is 45 days before, we're not gonna be flagging people in the system or anything like that. So if anyone wants to bring one, it has to be before that. If someone files a 229 challenge, that actually removes someone from the rolls. So there's a little bit of a higher standard of proof. It's preponderance of the evidence, sort of more likely than not. You really kind of want to be more careful with those, especially, think about it, courts don't like them when you get really close to the election to be removing people from the rolls. Especially because I think the last day to register is October 7th. So let's say this board got it wrong on someone, or, and then they can't re-register. So it's like the closer you get to the election, you have to be more methodical when you're reviewing them, I would say.
So if somebody files something like September 19th, the last day, do we have a window by which, you're saying is it the last day to register to
So-
vote that we should, or is that procedurally how people are doing,
Yeah, and.
I mean, we don't wanna
Yeah.
keep it
Well,
waiting
and
either.
also, so the 230 statute just says immediately,
Okay.
although the secretary's, or the new legislation has said that cannot, if it's September 18th or September 19th, it's gonna have to be after the election. It's not gonna happen before the election. For 229, there's no cutoff date. The way the statute reads is that this board has to set the date for the hearing within 10 days of receiving the challenge. That doesn't mean you have to hold the challenge within 10 days. It means you need to set the date for when you will have the hearing. Because in this challenge, Stacy has to send out notices to everyone who's being challenged.
Okay.
And it has to give them the date, time of the hearing, and they have to theoretically, about with the mail, who knows now these days,
Mhm.
they're supposed to receive 3 days notice of the hearing. So once she gets it, the board within 10 days needs to say, okay, we'll have these on this date, so that Stacy can go ahead and start generating the letter that will go to the person and that says, you've been challenged, your eligibility on the roll has been challenged, we're gonna have a hearing on this date. I recommend as part of that letter, going ahead and sending things like, if you need to change your address, here's this form. If you need to cancel, here's this form.
And for Forsyth County, I went and listened to Karen speak at one of the other regions meetings last week. And Forsyth County has an entire packet that they have already put together. So that way, if a voter gets challenged, everything that they need to fill out, whether it's change your address or that affirmation form, is all in that packet, and we can just give them a packet.
And
I
you
think
just
that,
slap on the address.
Yes.
Okay.
I think that would be very beneficial, so that way they're not trying to figure out what it is that they need. They have everything that they need in the packet, and they can do what's necessary to clear the challenge up.
Mhm.
And you think about it too, a lot of people are under the impression when you move, especially if you move out of state and you register to vote in your new state, they think the states talk to each other and you just go off. So I think a lot of people, it's not that they're trying to be registered in two separate states,
Right,
it's that
right.
they move and they re-register, so of course their name
Yeah.
will come off
Yeah.
the old registration
When you go get
list.
your new driver's license, you're
And
thinking you're good.
But you're talking about 50 independent systems
Yep.
and 50 different softwares and databases, and that's kind of part of what Eric tries to do, is to compare those databases, and that's part of what some of the people bringing voter challenges try to do, is compare those databases. Unfortunately, we just don't have like a nationwide voter registration system.
Mhm.
So a lot of times when people get these letters and they're like, what, I'm still registered in Georgia, and they may, or now they can go online and do, oh, let me just fix that real quick and take my name off. So this one, because this actually removes someone from the roll, so if you uphold the challenge, Stacy goes in and takes them out, and if they show up to vote, they cannot vote.
Okay. There's no affirmation, nothing to
There's no
sign.
affirmation,
They're
there's
just
no,
go.
if it's past October 7th, they can't even remember when voting starts, they cannot
would it be something that if they were adamant that it wasn't correct, could we still give them provisional and bring it in front of the
You
panel?
could.
Okay.
Okay.
Yeah, so if anyone is ever adamant that they should be on the roll, I recommend you give them a provisional ballot, tell them to come to that meeting, and in that meantime, in that 3 days or whatever, it gives, Stacy, give me all your information, why do you think you should be on the roll?
So basically what we're faced with now is to determine what we want should this ever come up. Because right now, we don't have policies and procedures. We have
State guidelines.
the state guidelines,
Yes.
like she said, but we have to actually know what sort of timeframes we want to respond in, and her having a packet together, whatever we're gonna have in the
Yeah, no.
policy.
I mean, I'm not saying you have to have a policy. I don't know if you will ever get a voter challenge.
Mhm.
I know they are becoming more and more common.
Okay.
So the metro Atlanta counties have been getting a lot. Forsyth County, so Forsyth, Gwinnett, Cobb, DeKalb, Fulton, and then I know that Chatham and Bibb and Richmond, I think, we are getting the bulk of them.
We did have a phone call, was it, end of last week, beginning of this week, with someone calling, requesting information on how to file a voter challenge. But first thing I asked them was, do you live in Pickens County? And they did not. So I feel like it's probably something that is coming our way, and it would be best to be proactive.
Agreed. Okay, so procedurally then, I guess what we need to do is look at what parts of any of the samples we have before us, or ask our attorney to,
Yeah, and I will tell you too, part of it, I don't wanna say is your risk level, but some counties are more conservative with voter challenges and are not as likely to uphold them and are more likely to just say, we'll send them a letter telling them, but we're not gonna remove anyone. Other counties are, yes, we will review everyone and do what we think. I think Fulton, for the most part, has just been sending letters to people and saying, do you need to update, rather than removing people. So part of that is gonna be up to the board. And again, you're weighing the evidence, so that kind of, differs too from board to board, is, what do you wanna consider for your evidence? So for like Forsyth County, like they will not accept any USB drives or CD-ROMs or anything like that people try to bring in. They're like, we are not putting that in our computer system. If you're
Fair
gonna
enough.
submit your evidence, you need to print it out and give it to us. Staff may then scan it and email it to the board, but, cause it can get lengthy, but they're like,
yeah,
we want a printed out copy, so that's something they have in their policy. They actually put in their policy sort of samples of what kind of evidence they will review. They have in their policy that they're not gonna sustain a challenge just based on social media, because we were having challenges where people were like, I looked on Facebook and it appears they live in California, and they're like, no, we're not using that as the sole.
Right.
So they sort of put that in their policy, like, these are unacceptable on their own social media, or,
Right. So I guess what my question is to this board, is, does anyone want to at least propose a motion that we adopt a voter challenge policy? And then if we say
Yeah, I would
yes,
just encourage
then-
everyone to read the ones that Stacy's put together. I can send around, I'll send you Gwinnett's too, because Gwinnett's recently, because they get, they rejected this one. They got one that was 35,000 names.
oh my goodness.
What?
35,000
The
names.
same challenger?
Yes.
35,000 what?
Voters on the roll. that they wanted to challenge, but it was just based on the national change of address data. So they were like,
Don't you have to
We-
give each person an individual voter challenge for
yes,
each
so
person?
they, what they do is they're like, we are not gonna consider it, because those are the people that are already gonna get the confirmation notices. And that's insufficient, so we're not going to review these, they'll go through their normal process.
So do we need to do this in phases, or can we just say, have at it? You can create something, we can review what we've got,
Yeah,
shoot an
if you
email to
read-
Stacy.
Yes.
Well, I think, I went through all these and I did not understand the difference between 229 and 230. So somehow, somebody ought to lay it out in plain English up here. This is one election and this is forever. I mean, why can't it say that?
Well,
Because
I
it's
did,
clear as mud.
I know, when I was looking at both of them, I said, well, this is 30, this is 29.
You know what I'm saying?
What's the difference? I kept looking
Yeah.
back, trying to figure out what is exactly the difference. And I was really hoping that you would say,
Yes,
you know,
so, and I've gotten
really
used
is
to
that.
just calling them 230 and 229.
I mean, if
That's a good way.
if somebody is supposed to say, I want to do a voter challenge under 229 or under 230, you have to tell them which one you want to do.
Yes,
Well, how do they know which one they want
Well,
to do? Because
and the statute says you need to specify which challenge you're bringing. It has to be in writing, although I mean, it can be email, it doesn't have to be, like a hard copy. I would say that most of the people I've seen bringing challenges, they are usually working with a citizen group or a statewide group. They're communicating with each other on, Facebook group or something, and they are sharing ideas. So usually they already know the terminology, know what they need to do.
it's kind of like coming down from somebody's managing.
There's even some, national groups that are working, and this,
International.
not all, national, yeah, not all states have this mechanism, so, I mean, some do, some don't, Georgia does, and it's actually been there since like the 80s, but it's just
Come to light
sort
more,
of, yeah, as it kind of comes, I think people have realized, especially nowadays, like, why do we have all these old registrations? And it is because it's a convoluted, I don't know how many millions are on the roll statewide. And again, people don't realize I move, it doesn't just change with
yeah.
me and.
But another thing that was interesting to me is who can actually challenge. Can poll managers and poll workers
And
cannot challenge, obviously, because you're within that window. So it's really a person or a group that's going through the process of trying to identify people on records,
Do
whatever.
they have to find somebody then in each individual county?
Yes.
That's how that works.
Yes, and that's, I think, what's happening a lot of times
Mhm.
is they're working on it sort of in a statewide level, they'll put out who do we have in this county or that county, or do we have volunteers, and
yeah, and in that ACLU guidance on voter challenges that I provided you with, it answers a lot of those questions. Like it answers what the role of a poll worker is. Like what is a challenge status? Who can challenge? What is probable cause? What are mass challenges? So I think the reason I provided you with that was because I think it really helps define a lot of the terminology that's in the code and explains it a lot better than the code does itself.
It doesn't say 30s and 29.
And I will say that part of what Senate Bill 202 did was say that a individual, there was no limit on the number of challenges they could bring.
Right.
That was not in the law
Yeah.
before, but they added that, yeah. So all election directors are cursing whichever legislature
Okay.
said unlimited.
One thing I think if we're going into this, we'd have to be very cautionary about staff giving advice to either a challenger or the challengee. You could really get in the weeds fast if you did that, so we'd have to have something.
And that's.
Yeah, that's why a packet
Like
being
a
ready would
policy.
be, yeah, and we have a policy.
And I'll add on to this, so I have been advocating for years, and it's never happened, it doesn't happen now, that the state election board put together statewide rules on voter challenges, because right now, it's up to each county to put together their policy, based on the law, or based on the Secretary of State does training, but there's no election board rules on any of this, and.
One of the ones today that was heard.
Oh, they did, so I know, did they move forward?
They withdrew it, They withdrew it, and the chair of the state election board is going to consider working with the individual who submitted the petition on a rule for the state election board. So it will come up again. They've just withdrawn it to be able to work on it in collaboration with the petitioner and the state election
So,
board.
at some point, the state may come out with, these are gonna be the rules for all counties.
But we
But
kinda don't
it
need to
hasn't.
wait on that
No,
either,
and
so, yeah.
I've been waiting since 2020.
That's kind of what I was getting at, like, it might take a little bit longer, yeah, unfortunately, so.
And this is something that I feel is very time sensitive, so we need to, do it quickly, and turn something around so that way we can have a policy to enact before this election.
So if you could email Stacy and even just,
And you have one
this
other,
part of Fulton's and this part of.
and you have one other one, you said Gwinnett, that you
Yeah,
could share?
let's see if I have it on my phone and I'll
Okay.
send it to you. I'm not positive it's on my phone, I may have to get
Is
it on my
everybody
computer.
comfortable with kind of sending in their thoughts of what parts of which one? And you need to be obviously specific that
Do we wanna have one that has full of legalese, like OGCA, blah, 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 blah? Or do we wanna say something that says, like the ACLU document, that says,
I think that obviously we can each like submit what we think and then we can kind of narrow it down and vote on it. If we don't have, there's not a requirement to put either the legalese in it, or if we wanna make it like a little bit simpler for people to be able to better understand, how the whole, which the 229 or the 230 is, so.
well, I guess if you're saying that the people who are gonna be filing voter challenges are people who are gonna have
A little more knowledge.
support behind
Yeah.
them that knows what it's all about, I guess it's okay. Thank God.
I don't have it on my phone, I was hoping I had it on my phone. Remind me tomorrow, no, it's on my computer, the Gwinnett, or maybe on their website.
Terry, you have
So
thoughts?
Yeah, so, what would be really helpful for me
Yeah.
is, we have the legislation that revised, and all I can see is it revised section 230, but not 229.
Yeah, they didn't revise 229.
Okay, so can we get a copy of the statute as revised, rather than having to, again, look back and forth at the old law and the new law and putting them all together, that would be really helpful. And then we can look at this, and I guess my only question is that if we send in our comments, is that a problem?
Somebody's gonna be
An open records issue. Not open records, but a sunshine, send a sunshine.
They'll be subject to open records.
Yeah,
But,
you would
yeah.
be sending them to me and I would be forwarding them to the
Okay.
attorney, so it would not be in violation of the sunshine law.
Okay, so just don't copy everybody on the whole board.
Right,
Which
just
one-
send them to
which one was-
Stacy, yeah.
Was modified?
230.
So two
The
twenty-nine.
easier one, I think.
Just send
So
everybody,
229 is the same as it was.
do we,
That's what I
Stacy, do you
got
have a
here.
deadline? That,
I would
Or
like
Karen?
for us to be able to adopt a policy by September. I know that's a month away, but I think that we need to get ahead of it because we don't know what all is gonna come, before November. And we do have the state guidelines, the code sections that we can follow. But if we have something to supply, challengers, cause one of the questions that was asked when we got the phone call was, what do you require for a voter challenge? And that, like I said, that was my first question, was where do you live in Pickens County? So just a layout of what our board is going to require for voter challenges and, what they will accept
And
as
then
well.
Also, like these, they're in the news now, but these come anytime. So, next year it's the Public Service Commission, that'll be city elections, so there's not as much. But a lot of people bring those slower years to maybe bring these, because then the board and staff have more time. I think preferably staff would always prefer it to be in the, slower election years than when you have state and federal.
Would everybody be comfortable if we did 2 weeks from today, by the 20th, that you have your stuff submitted to Stacy? August 20th. Is that good for everybody? Okay.
And so Stace, you said there is state guidance also from the
Yeah,
Secretary of State?
Yeah, there's code section about voter challenges, which is the 21-2-229 and 21-2-230.
Oh, okay, but
Yeah.
not anything in addition to that?
No,
Okay.
they did do one training session, but it pretty much just went through the statutes and then they've done what they need to do to
I feel like
mark
yours
and
was more
Jarvis.
in depth than their training was on it.
So by the 20th of August, if everyone will please review the samples that we've got. And we will also receive, hopefully tomorrow, a copy of the Gwinnett one to also look at as an example. Your thoughts, your recommended procedures of the policy that we should adopt. Email Stacy by August 20th, please, so that we can move forward with creating and adopting a voter challenge policy here for Pickens County.
Are we gonna do two separate documents, 29 and 30, or just one like Foresight?
I think Versailles. Just
I
one.
would just do one, because a lot of it's gonna be the same.
Okay, so your recommendation would be to go with just one document. Okay,
And can you provide us with the revised Forsyth County, because you said they
Yes,
revised it today?
they revised it today, yeah.
Okay.
Major
That'd be great.
changes.
They added in, so part of the change with Senate Bill 189 was that if someone does submit just change of address data, national change of address data, that would not be sufficient for a challenge. So they've added in that if someone does that, then the board essentially was telling the director, you can go ahead and tell people that that's rejected, rather than before it was going to the board for the board to say, no, this isn't sufficient.
Okay.
So they basically put in their policy, if this is all you do, staff's not even gonna take it.
okay.
So, okay, and then I just have one other question, and that has to do with the way that the challenge is submitted. So looking at the Forsyth, it's paragraph 4. So it says hand delivery, okay, regular mail, well, we know that'll be worthless, and email. So, with the email, if we're telling them that they can't do it on a thumb drive or something like that, but does email cause I don't know the answer to this, could that potentially cause a security issue with the county's computer systems?
So we do allow people to submit PDFs. And that may be a conversation to have with IT.
Right.
So I know Forsyth did that with IT to see, what will you allow. So they do allow them to do the PDFs. And sometimes staff have to redact them, pursuant to Open Records Act requests.
So what's the difference between an email from Stacy from Susie Q and somebody submitting a challenge as far as the security aspect of it? They could get the same thing today, right?
You're saying she could get sent something corrupt?
Send it
Yeah.
corrupt.
Yeah.
I mean, I would
She can get it
definitely
today regardless of whether it's part of the challenge.
recommend not opening a weird
Yeah,
file.
but you don't know, but you wouldn't open an attachment
Yeah,
normally, would you, unless you know
Not
who?
unless I knew who it was from.
Right.
Okay.
So
And
that's,
we, our IT department has added, some additional, layers of security where if it's somebody that we don't normally get an email from, it actually holds it in quarantine until we approve it to get it out of quarantine for us to check it. So if it goes into quarantine and it's not somebody that I know, I just leave it in there. I don't even get it out.
So I guess the question, Terry, that you're trying to determine is this the best way, or do we wanna just limit it to mail or in person?
I don't know, I mean, I think Stacy ought to talk to the
Yeah,
IT
talk to the
department
IT
and see
people
what
and
they say.
See what they say, yeah.
If you're leaving it in quarantine and you don't know the person, then you never get open, right? So I wouldn't do emails.
Yeah,
If there's a possibility and when somebody send it to you, and you're not knowing the person and not willing to open it, then just don't have them email it to you. A letter or a document.
Yeah.
The codes are, the code
It
section
just says
does,
in writing.
it says in writing, and the
Right.
Secretary of State says that an email is a form of writing.
Okay.
So if it was something that like in
Well-
in the contact or subject line, it said, voter challenge, if it was something that I was concerned about with an attachment, like a PDF or
You
something,
could
I would
call them
send it to
voter.
IT and let them open it.
Okay, so you do think you have a procedure to be able to accept them where it wouldn't
Yeah.
jeopardize anything? Okay.
Yeah, I think most, we have, I know, you probably got one too, there was something weird going around recently with an Open Records Act request that all the counties received, and I know a lot of directors sent it to IT first, be like, is this okay for me to open?
One from Philadelphia.
Yeah, it was like some weird email
Yeah.
address, yeah.
Yes.
All right, well, exciting times coming, people, exciting times. That's all we can say, so. All right, thank you, Karen, for all the information on that, I appreciate it.
Unfortunately, some of I've learned because.
Trial and error? Yeah, I understand.
Yeah.
All right, the next item on our agenda, for tonight is new legislation in the SEB rule updates. Stacy or Karen, who's taking lead on this?
Well, I'll start by letting the board know, I printed out all of the bills that were, signed by the governor pertaining to elections, except for one. And it didn't pertain to us because it was,
As a probate.
Senate Bill 212, which ended the duties of probate judges, and since we were not under the probate judge, I just did not even include that. But anytime any of the board members would like to go and look up, any bill, they can go to the website, which is www.legis.ga.gov, and you can, search for bills, or you can, if you know the bill you're looking for, you can put in there. Always look at the current version, whenever you're researching anything. But I went ahead and printed off the current versions of all of the ones that we're gonna go over tonight. And we're gonna start with Senate Bill 189.
I have a cheat sheet.
We like those.
So,
G.ga.gov.
yeah,
but it's just the legislation, it's not the revised version of the bill, of the code section.
No, this was the new legislation that was passed in this the last
Right,
legislative session.
Right, but you see what I mean, it's like so you read these bills, then you have to go, the as passed bills, and you have to go back and look at the statute as it was previously and go, oh, well now this sentence instead of says can says shall.
and they're in
And
the
that's really
process
hard,
of
and so
updating.
that's,
Yeah, and we'll
what
get
we need.
they're in the process of updating our code books, and they will get us new code books, and we'll distribute them to the board members once we get them. And
But can't you get it off Alexis?
I've got
It
it.
isn't, I don't know if they're all updated yet. I know they're in the process of updating some. Westlaw is better, I think, at keeping up than Lexis, but,
I found
Some of
something
it's
called casetext.com, and I've got the Georgia code. 21-230 with the latest version, the 2024
Okay,
section.
yeah, not all, some of them, because most of them went into effect July 1st, so they started updating.
What's that? What?
It's called casetext.com. I just did a Google search for Georgia code 21-2-230, and this came up, and that's why I put it on my phone, and that's how I got it. I don't know if
If it's the most, up-to-date version, but.
I don't know if other things I saw didn't have the update version, but this one did.
Okay. Thanks, Becky. All right, Stacy or
So, I'll just summarize some of the changes. It removed the Secretary of State as an ex officio member of the State Election Board, so kind of really separated out the State Elections Board from the Secretary of State's office. So it's, although their budget is not very large, I think they have 1.5 employees, so, and all volunteer members on the board. It has information, this isn't gonna really affect anyone, about, you or staff are not allowed to have, or be in business or have a business that deals in election equipment or election paper or, any of those things.
And that's section 3.
Presidential candidates, if they are on the ballot in at least 20 states, they can qualify to be on the ballot, rather than having to check all the signatures like Stacey's probably doing right
We
now.
finished ours.
Okay.
And that's section 3.1.
Home, and I don't really understand this provision necessarily, I don't think it meant what they were going to. So it's always hard to figure out where to register homeless individuals. And I think generally what most directors do is register them literally where they sleep at night. And that might be behind the Walmart, or it might be at the homeless shelter, or something like that. The legislation doesn't change their registration residence address, so you still use the residence address, but it's supposed to make their mailing address all be the elections office. So any homeless individual who registers, it'll be the elections office, but then that means when Stacy sends out election notices,
comes right back to her.
they're coming right to her.
And then what?
It doesn't make it, because there are a lot of churches and even the post office and homeless shelter and various places offer mail service to homeless individuals. This sort of takes away that choice and makes it the elections office, but then Stacy's just mailing herself.
Not quite sure how that all.
It would have made more sense if they were going to say any homeless individuals, your residence address will be at the elections office, but that's not what it says. It says the mailing address.
And Becky, to answer your question, what that will do is if I send out correspondence and then I send it to our office, it's gonna be returned. Well, then that's gonna be returned mail, and then they're gonna go on a clock, of no contact. And it's going, I think it's going to cause problems later on down the road, but that's the legislation that was passed, so.
And I know there's already litigation filed against that portion.
It
It's already
might be
being
something that will have
challenged.
to be amended.
The homeless portion is already being challenged.
And that,
In federal court.
that section, which is section 4, pertaining to homeless voters to use the registrar's office, that actually does not take in effect until January 1st of 2025. In Senate Bill 189, the sections that took effect July 1st of 2024 is gonna be section 3, section 3.1, section 5, section 8, section 10, and section 11. And then January 1st of 2025, section 4, 9, and a portion of 10 will go into effect January 1st.
Like how we divide sections. Makes it even easier.
Sections and the number.
Yes, so July 1st, 2024, section 3, which was businesses contracted with state voting equipment is what it pertains to. Section 3.1 was ballot access in 20 or more states
And
for the presidential.
section 3.
3.1.
This is on 7.1.
Yes, ma'am.
3.1 and then section 20.
Section 5 is probable cause for voter challenges.
I'm just writing down the numbers.
Okay. Section 8,
Yeah.
which is the mandated by law that absentee by mail report has to be, or absentee by mail has to be reported by 8 p.m.
Okay.
on election night. Section 10 is advanced in-person voting has to be tabulated by 8 p.m. on election night. And then section 11 is a pilot program for auditing paper ballot images based on the QR code.
That's all 7.124. That's all 7.124.
And then January 1st is section 4, which is homeless voters to use registrar's office address.
What section was that?
4. Section 9 increases the chain of custody for absentee ballots. And then section 10 is for open records requests, ballots must be at 600 DPI.
Okay, so you said 7.1 was section 10 and also 1.1 section.
Yeah, I had
Yeah,
sections.
part of it is,
Part of it.
That's, I said they're splitting a section, makes it even easier.
And Karen can tell you a lot more about it than I can. Those are just my notes
Okay.
of the
Yeah.
synopsis.
It's like bills will usually say they become effect the day they're signed or the day it has to say the day it's signed or another date in the bill. And then if neither of those are there, then they take effect July 1st.
But in this case, section 13 tells the effective dates of each of the sections.
Section 13 is what?
Yeah, it tells the
It tells
effective
the
dates of each of the sections.
And Senate Bill 189 was really the big one. It was sort of the Frankenstein elections bill. It was like it took a bunch of election bills, where you have legislators from all different parts of the state submitting them, and then they kind of got all mushed together into one bill.
Section 7. It's, okay, it's in section 13.
okay.
Another change, so 21.2.217 is already in the law. It's sort of those list of factors that the registrars look at to decide what someone's residence is. It added some sections to that. So, you can temporarily leave the jurisdiction, but you don't necessarily, say you need to go take care of an ailing relative for the next 6 months, like you don't necessarily lose your residency. But it clarifies even if you are intending to come back, if you register to vote somewhere else, you essentially lose your residency. It also says that having a post office box or one of those, UPS mailbox stores is not enough to show that you reside here. So it adds that. It also, and that goes, the home list goes into effect January 1st. It also clarifies, this is where the 230s is, where you can't hear challenges within 45 days of the election. And then also So being on the National Change of Address database may be a factor in considering residency, but it can't be the only factor in deciding someone's residency. I'm not sure my notes are in order. This will not apply to you, if counties with less than 5,000 registered voters can use hand-marked paper ballots instead of the TPN machines. I don't know how many counties that is.
I was saying, obviously that's above what we are, so
Yeah.
we can't,
Yeah,
we don't qualify.
No, I don't know how many counties that is, but even then they have to get Secretary of State permission to do that, or State Election Board, I think. One thing that will go in effect, but not until July 1st, 2026. So it would be for the next governor's race, is that the scanners essentially should be scanning your choices, not the QR code, if there's a QR code on the ballot.
And that's in section 7.
But that one is very far out because that
Changes new equipment and all the
changes
other.
the equipment, software, scanners, all of that, yeah.
And so that's July of 26, is that
That's
what you-
26.
26.
And actually I wrote July 1st, but it may be January 1st.
I think it says July
It doesn't say
in
July,
section
okay.
13.
I just looked down and I was like, wait, did I mean July or January?
I think it said, let me double check. Yeah, July 1 of
Okay.
2026, section 7 of the act.
So it wouldn't be in effect for the primaries, but it will be in effect for the general governor election, yeah. I'll let Stacy actually talk about the absentee by mail and all those changes, because that really affects
Yes,
you.
the section, which is section 10, talks about that we have, to tabulate the, absentees. Or I'm sorry, section 8,
Yeah.
we have to canvass, which is open up, and have everything ready with the absentees all the way up until I think it's the day before the election. For us to run through right at 7 o'clock, because we have to report that to the state by 8 o'clock now. And then also, we have to tabulate our early voting totals to the state by 8 o'clock. So, where we normally start, doing all of our precincts, uploading the results from our memory cards to the state first, we're actually gonna have to start doing, absentees first, which is gonna require us to, change things around a little bit, because we're used to our board members going out and picking up the memory cards, one from each party, and splitting the precincts up and bringing those back for us to total, quickly as possible. But if we have to have board members on the absentee ballot panel, then we're not gonna be able to have equal representation going out to pick up these cards, and we might have to pivot and do something different. We have talked about canvassing early, which is, depending on how many ballots we end up getting back, we might start at, 10 o'clock that day. And then we would require everybody that sits on that panel to be there at 10 o'clock, to start that process. So we don't know exactly what that's gonna look like for us. We're working through it, figuring it out. But we're gonna have to make some changes based on the new legislation and how we have our board members go out and act on their board duties, because we have board members that check on their precincts throughout the day and checking on supplies and take lunch, and if they're sitting on the panel, they're not gonna be able to do that. So we're just gonna have to restructure election day a little bit differently.
And-
But I don't see that it's gonna be an issue because we're already doing it, we're just doing it later in the evening now, we're just gonna have to move our timeline up.
And you can still accept absentee ballots till the polls close.
Yes,
So that also will affect how far you can go with, you can canvass, like say, but you can't start running them through till 7 o'clock when the polls are closed for tabulation.
yeah, and Ed and I had this discussion, earlier, one thing that, I foresee it being a little difficult to do is we actually group our, absentees by precincts, so that way when we're doing our batches, it's a little bit easier when we go to do our audits, to keep all the precincts together. And if we start running, absentees through that have came in, up to the day before the election for precincts, and then we get, which I don't think that we would just get a ton, on election day. But then we would have to look at also doing something a little bit different with that batch as well, because we keep everything else together in batches by precinct. So it's just pivoting and doing it a little bit differently, but I don't see that it's gonna be a huge hurdle for us. We're just gonna have to, restructure the way that we do election day.
But unfortunately, just for what it's worth, 2 of our regular board members, they're working folks, so 10 a.m. might be a problem. And I know we're gonna have to overcome all these obstacles, but just saying, we don't have enough on the list to have some backup, we may have a problem.
The board members for,
Now, not board members, but Mr. Mora and them that come in and actually help the processing in the evening is not so bad when because they're not working, but if they're working from 10
and
a.m.
I believe on election day, they actually, set that aside to do nothing but, election work. Because I believe Mr. Mora normally is at one of the precincts as a poll watcher. And him and I have talked about, this, change in legislation and what we would have to do, and they are on board with whatever we need as far as, they will send us the people to sit on the panel, and give us that list to have signed off on for whatever time that we need.
Right.
And if we, back in 2022, I think we had close to 500 absentee ballots, from start to finish. We opened them, ran them through the scanner and completed everything within a couple hours. We had a number in our mind, if we ever got over about 700 absentee ballots, that would be too much to try to run through on election night. So we had already been preparing if we ever were to get over that to canvass earlier anyways. And it's not, something that's new as far as canvassing early. There's a lot of the larger counties do that, and it's just a process of going through, letting the Secretary of State know that we're canvassing early, running the proper advertisement in the legal organ, and then just getting the people to sit on the panel to do it.
Okay, good.
Well, and just in 2020, I participated in that. I wasn't on the board at the time, but I participated in one of the panels that opened the absentee ballots early. And because, well, I assume this is why, we did it at the courthouse. The judge closed the court, well, she closed the entire courthouse, but in any event, one of the courtrooms was made available for the panels to open the ballots. And of course, there were members of the Board of Election there as the supervisors, and staff also during the day, but, anyway, there were a lot. I don't know how many there were a lot.
The Secretary of State and the advertising, like you could also put in there no earlier than, like if you're not sure exactly what time you're gonna start, depending on how many you get, you could put, we may start opening absentee ballots no earlier than 9 a.m. on this date, and then as they come in, you're like, we don't need to start at 9. You put a sign on the door, we're not gonna start until noon or something.
When's the last day to request an absentee ballot for the November election? Do you remember? So we would at least have a number of potentially how many we could be looking at coming back in.
October something.
Give me just 1 second, I got it right. It's on that handy dandy, information sheet flyer that Mary.
Yeah, that's what I was just trying to find.
October the 25th is the last date to request an absentee ballot. The
So-
first day to request it is August 19th, and the last day is October 25th.
So by October 25th, we'll at least have a potential number of what we could expect
And,
to come
and
back.
based on the number that we know will be coming back, we will be able to tell, like, I mean, should we do it at 10 a.m.? Like, do we have enough that we should actually do it the day before? Like, you know, it's all gonna be based on the numbers that we receive back.
Okay.
One thing I wondered about Tuesday, and I don't know, you tell us, is it possible for someone other than a board member, like could we ask the sheriff to appoint deputies to pick up the
They do
the
not-
card?
I will tell you this, they do not want to, touch anything election related.
Okay,
Especially with this year, the sheriff being on the ballot. So,
good point.
even as, you know, moving, our sealed, documents that go to the clerk of court's office, they would not even touch those. I took those over, escorted by deputies, but they would not even pick up a box because they don't want, you know, any association, anything that could tie them to somebody saying that they might have tampered with something. They're there just for observation.
and is that gonna impact, cause normally there's an officer there in the evenings when we pick it up, but they'll still be there.
Yes, they're still gonna be, that's actually a code section, that they're required to, have deputies at polling locations. So that will not change.
Okay.
It's just they would not be able to, pick up the cards and return the cards to us. And we haven't got that far down, in the agenda yet about the state election board rules. But one of the state election board rules would actually, if it was passed, would, really hinder, us getting our results back with board members, you know, being on the panel for absentees. And then if it passes, the rule that they're looking at, it would require 3 different, poll workers to take out all of the ballots out of the belly of the scanner and individually count, not tally, but count just the number of ballots and compare that with the number on the scanner. And if we're not going and picking the cards up and we've got our manager and 2 assistant managers counting these ballots, plus trying to finish up the paperwork and break down the equipment and properly put the equipment back up and make sure it's secured and sealed, it's really going to push us at reporting all of our results to the Secretary of State by the 12 p.m. deadline that the code says that we have to.
Mm-hmm. And it's gonna get late. It really
I'm
potentially
just
can.
going to bring my pajamas on election night.
And we talked about when you have a poll manager and 2 poll assistants that have been working since 5 a.m.
14 plus
and now
hours.
they've got stacks of paper and they're trying to count them after a long day.
I mean,
They're gonna not count it right the
Yeah.
first time.
No.
chances
you know?
of them miscounting it, the chances of accidentally, because they're tired, knocking a stack off and one maybe, you know, going up underneath the desk, or I just feel like the chain of custody is going to be lost with that SEB rule that they're looking at. So, but that's on into you know, us talking about SEB stuff. But I just, because that goes hand in hand with this bill, I just wanted to bring it up then as well.
The chain of custody. Do you wanna talk about that one, or- Hold on. What is that? 10?
Chain of custody is section 9.
Section 9.
Yeah. it's like-
Oh my gosh, okay.
Yeah, these are effective January 1st. Although I think a lot of it already is happening. So, absentee ballots shall be securely stored in a sealed container or in a sealed room. I was gonna say, I didn't take many notes about it, not everybody.
And any of these bills that we're looking at, when you go home and need some light reading, any questions that you have after reading them, feel free to email me and I can forward those questions to Karen and get her to answer any questions that you have. Because some of it, whenever I look at it, some of it makes sense, and then some of it, when I look at it, is like me trying to read Chinese. I don't understand it, I need her guidance.
Yeah, so I mean, a lot of the ones with chain of custody, I think we're already probably in a lot of policies and procedures anyway.
Some of it sounds like things we're already doing.
Watch, as you unseal containers and putting it in tamper-resistant containers with numbered seals. The Secretary of State's supposed to come up with the chain of custody form. I don't know if they've done that yet. Each person sealing and stuff will sign that, which you may have if you're.
Yeah, I think a lot of that is already things that Stacy implemented, we have already been doing up here in Pickens County. I can't say for every county that's doing the same, but it's things that I think have been going on up here for sure.
The same section as the 8 PM and, sometimes with this legislation, when it gets to the first election and if no county makes that deadline or the majority of county makes that deadline, and it may be something, they tell the legislature like that, it's gotta be 9 o'clock or something.
Yeah.
So I think all of that is basically making sure everything is sealed, signed, who touched it, that there's multiple people, watching it. Then, the 600 DPI, so currently, I believe the scanners produce ballot images at 200 dots per inch. So when someone makes an Open Records Act request for the ballot images, they're getting that ballot image at 200 DPI. And this is one that goes into effect January 1st, and it could create just logistical issues for staff. Is that if someone makes an Open Records Act request and they want copies, they can request copies up to 600 DPI.
Of the ballot images.
And if your ballot images are not at 600 DPI, which they are not going to be because that's not what scanners scan at, then for purposes, so the ballots are gonna go to the clerk who holds them, and normally it requires a court order to access them. But for purposes of this, it gives authority to staff to scan the ballots at a higher resolution.
Which means we would have to go over to the clerk's office. We would have to have the clerk's office bring the ballots up to a room, or so, if they have a scanner, where the ballots are held, the person requesting this can observe while this is being done. But we would have to scan by hand every single ballot at 600 DPI, but we would have to do it at the clerk's office using their equipment. It would take probably more than one staff member to do it.
Now, it is under the Open Records Act, so
There's a charge for.
there's a charge, and it will probably be significant, so I anticipate people complaining once come January 1st when they start asking for these. And they're gonna get some very high estimates, but you think about it, like they're unsealing and pulling out and resealing and then
Multiple
running
men
through
or persons
each
present.
one,
Yeah.
and they're not allowed to touch them, so it has to be staff. Now, once you do it once, you can save those images, and if anyone makes a request later, they can send it out. Now, I don't know if the state is looking into upgrading the scanners so that they are at 600.
I was just saying, my question kind of comes in is, does our clerk's office, do we know if our clerk's office has 600 DPI?
Well,
What do we do?
if they have the same scanners that I do in my office, you can select 600 DPI.
Okay.
But my question is, that's not our office, we're not using our equipment. How, when we're scanning this, how do we store that to put it on, let's say, a flash drive? Because we're not using our computer, are we,
What do you do where
with the
the
change?
images then?
And with the information, you're putting sensitive information onto, it's still county computers, but it's a different department, and, I
There
have
has
concerns
not
about it.
been any
No,
guidance.
none whatsoever.
It's gonna create problems. I'm glad it's a January
Yes.
1st,
Yes.
at least.
And one question, or one thing that Karen and I talked about was the possibility of going ahead and after an election, our office, just because we know this
Scanner.
could happen, go ahead and start scanning those ballots into our system. But the thing about that is running out of storage and the time. And, it's like, you have to keep that for 2 years. So it's, in a big election like this, how much storage is that gonna take
Or
up on
to
our
do-
server?
Or recommend do 200 ballots, time it, so an approximate time, so then multiply that out by however many ballots there are, so that if someone does make the request, at least from a cost perspective,
You
what
have
it
something
costs.
to provide.
There's still issues though to work out, especially a lot of counties, the ballots are in the custody of the clerk of court, but especially counties with smaller courts, they have warehouses, like they're insecure. So even though it's legally in the custody of the clerk of court, it's not in the courthouse. It is in a locked self-storage warehouse where there's not computer equipment to scan, so do they have to bring the ballots back over?
Which is also another question, you two discussed doing it in advance. Is that permitted with the fact that the ballots have to be sealed and that sort of
It's,
thing?
Yeah.
Questionable.
Yeah.
That's why I really, really, really want the state election board or secretary of
Give us
state
guidance.
somewhere to give us guidance, and I don't know that they will.
Mhm.
That's maybe something to email the state elections board, asking please give us guidance on this.
Yeah, because if we technically can't do it, it need to be.
Also getting maybe clerks of court.
Yeah.
Yeah.
Asking their, cause they're gonna be dealing with this too, so, their representative organization and stuff, can you give us guidance also?
And if it's something if they request it, we still have before we seal the ballots, while we still have them in our office, it's one thing. If they request it after we've already sent them to the clerk of court, that's gonna take myself and one other person out of our office, to be going and doing this for however many days, depending on how many ballots there are. But the one thing about the open records is if it is over a certain amount, which I'm sure that this is probably going to be, we can request them to prepay for this before we actually do it. And in most cases, if they have to pay for something and it's a large amount, they never follow through with their open records request. They just never respond back. So. But I'm sure that there will be some people, who will follow through with it, who will pay, the fee for the open records, and then we will have to do it. And that's one thing we will need to do. We'll need to get with the clerk of court about, a plan to do it, if it's something when we've already turned it over to their authority.
Yeah.
Because I know back in 2021, the Department of Justice contacted me about wanting copies of ballots from the 2020 election. And they had already been submitted, of course, to the clerk of court. And when I contacted the clerk of court, she said without a court order, she was like, I cannot let you access those ballots, but after you've already turned them over to me.
This brings up a lot of questions.
Yeah, so so I mean, that question is addressed in the statute because it says they can, give them up pursuant to this request. But, so my question is though, why would the scanning have to be at the clerk's office? Is there a statute somewhere that says that has to happen?
Because once the chain of custody, I have signed them over to the clerk's office, I can't take them back to my office because we can't be going back and forth with the chain of custody of it. So once I have signed them over to her, they are in her possession until she presents it to the grand jury for proper
Unless-
instruction.
The clerk of court approves them moving, but again, like anytime these boxes and seals get moved or open or anything, it's,
Yeah.
It's a security issue.
Yes, it's a very
Huge.
big security issue.
And especially because clerk of court's another elected position too, so.
I don't even know how aware they are of this.
Wow.
Like-
All right.
Let's see. That changes something, with special elections. Not what that did. Oh, it just changed the primary special elections. Change that. Right. That was the biggest bill.
That was a lot.
Yeah.
It
That
really
was the
was.
first- that was
They
just-
did cram as much as they possibly could in that one, didn't they? I mean,
I think it started as like 10 different bills and
Yeah.
then it got,
yeah.
974 is the one that went into effect July 1st that caused all the counties to have to destroy all of their expensive ballot paper, or at least I know a lot of counties are holding on to them for now,
Yes.
just in case. Supposedly everyone's getting new watermark paper because that's what this requires, but from what I understand, the Secretary of State keeps saying it's coming.
I was told it would be the beginning of August, and that's what we're expecting, so we'll see. But we have not destroyed our, other paper that we had, just until we get our new paper in to make sure that we have what we need, because we don't wanna be, stuck come November if legislation were to have to be changed because the paper is not ready and it's not have paper, for the BMDs.
What's the,
Go ahead, Ed, I'm sorry.
what's the financial impact on
That's what I
that?
was gonna ask, yeah.
It went from, we had already purchased, paper last year because we had extra money left over in our budget. So we'd purchased paper and it got us through all the way, through May, and we have about 35, reams of paper left. The financial difference, where the old paper was $60 a ream, it's $65 for the watermark seal. But we did have to turn around and we only ordered enough to get us through November and the possibility of if we have a runoff in December. So we ordered about 65 reams of the new paper, and that should be enough to get us through this year. And we were gonna, since we don't have an election until June of next year, we were gonna kind of see what legislation might change next year before we end up ordering more paper.
And we don't get any credit on the old paper, is that correct?
We had hoped that there would possibly be maybe a buyback from the company that we bought the paper from. But again, chain of custody, it's going from, their warehouse to up to election offices. And then they don't know who's touched that. And then going back to them, they wouldn't buy back. So the counties just have had to eat that. And we're fortunate, like I said, we only had 35 left. There's counties who had ordered thousands of reams that, the Secretary of State told them, just properly dispose of it, have it shredded.
Can you do anything else with it?
One thing that we have possibly, considered using ours for, since we have such little left, is just for LNA testing. And if that were the case, we would keep it separate from our watermark sealed paper. And it would be something that I would have to oversee very carefully to make sure that that paper did not get mixed in, with the watermark seal paper.
And you have to wonder with some of the other things that are, if they're gonna be changing the equipment, how long that paper is actually gonna be good for, if there's gonna be something else they're gonna do or need. So good call on getting us through this end of the election year, and then we'll go from there,
Yes, and
depending on.
The code section, the code book says that the Secretary of State deems what kind of election equipment that we use. And if we end up, in the future not having the same Secretary of State and election equipment changes, it might not take this same paper.
Yeah.
So there's a lot of factors to consider, and I'm just gonna do what I can to get us by until we know more information about what we're dealing with.
Right. Okay.
This bill also says that absentee ballots are supposed to be scanned at least at 600 DPI or the highest resolution possible by the certified voting system, which currently is 200. So, I haven't heard anything if they're looking into updating that, but.
What do you gain with the higher resolution?
What are we gaining with
What do you gain with the higher resolution?
Oh, I don't know. They slower scan.
Slower scan,
It's also mandates ballots.
Depends on how good your vision is.
The ballots that are printed have to be scanned at least 200 DPI, which is actually what's already happening. And the Secretary of State's already started doing this, where rather than people making open record type requests for the digital ballot images, they now have a website. All counties upload them to the same website. You can go and search by county and then election. And
Does
look at all
this
the ballot images.
change the scanner that you use for the absentee ballots? Do you need to have a different scanner
There's
now?
not the
There's-
one that we have only scans at 200 DPI.
So there's
So
nothing,
there's,
Unless the Secretary of State changes them
Yeah.
out.
it would require a software upgrade that was approved by the Secretary of State in order for us to be able to scan and uphold that code.
It changes the risk limiting audit somewhat. It reduces the risk limit. So currently it's 10%, although the Secretary of State has been mandating 5%. This will put it into the code that by 2028, the risk limit's 5%. So basically, the number that they select means there's a 95% chance that the total is correct. I think I'm phrasing that right. There's some mathematical behind the scenes that happens with that. So, but that's already sort of been their unofficial policy anyway. It changes the contest to be audited. It must include a race, a contest at the top of the ballot, and then it has a list of various races. You have to have at least one of those. So like Senate, Governor, Secretary of State, there's a list in it. So you have to have one of those
and that
also.
still gets assigned by the Secretary of State's
Yes.
office, correct?
It's 2 audits per election with 2 or more statewide races.
Okay.
But again, you can always, as a board, choose to audit more, if you want to, you have to do the state's audit and the state's required audit. You can always choose, and we're going to do the county commission here or something.
And I will, I think each one of the board members has been, to at least one audit. There's no good way if there is, 2 or more, statewide races that we have to audit. There's no good way to go through and audit, at one time. We would have to do one race, go all the way through that audit, and then once we finished it, we would have to pick up that batch and do the second race that is requiring. There's no way to do 2 at one time.
Alright, then House Bill 1207, and I think most of that went in effect July 1st. Any person employed by Stacy would have to be a citizen.
What?
Any
citizen?
person employed by Stacy would have to be a citizen. So currently it's required for poll workers, but people in the office could have a green card or some things. But this changes it to basically anyone working in elections will have to be a US citizen. It also allows if no one qualifies for like a partisan race, or nonpartisan, you can keep reopening qualification until someone qualifies.
Till they have somebody who wants to do it.
Yes, until they strong arm
Interesting.
someone into qualifying. Candidates will be allowed to review the ballot proof that comes back from the Secretary of State to see if there are any changes. But they have 24 hours to review it, so,
And when does that go into effect?
January 1st. It changes that 250 rule that was in there that you're supposed to have, machine per 250 person precinct to allow the board and the director to look at historical patterns for that precinct and decide what's
It
best.
will allow us to take into account how many people out of that precinct has voted at early voting. And where the code section before said that we had to have one machine per, was it 500 voters, 250 voters? 250 voters, but we have someplace like, Nelson, who doesn't have that many people show up, but we're having to send, as many machines as they have registered voters. So this will allow us to take into account how many people from that precinct has voted at early voting and adjust the number of machines. So I think it will really help us out.
So, and it adds some language for poll watchers that basically, it's still vague, but shall be entitled to sit or stand as close as is practicable to the observed activity so as to be able to see and hear the poll worker or election official. I know that there's some rules that were being considered today at the state election board meeting regarding poll watchers, and I don't know yet what came out of that. Do you know, were you there for that part?
Oh, I spent all day.
It was playing in the background, I think, every time.
I believe that was one of the only ones that was passed. Yes, it was passed, so it is, was passed to initiate rulemaking procedures. So the state election board will meet again on the 19th, and then they will, address the rulemaking procedures for that rule.
And I know one of the things they were considering is that poll watchers would be allowed in the tabulation area.
So I really don't feel like listening to the state election board. I don't feel like it affects us because we already give our poll watchers, the maximum access as it is. They can come into our office on election night. They can walk all the way up to the window. That's the whole reason we put the window there, is so that the public, can watch what we're doing when we're tabulating. Some of the board members for the state election board had an issue with this because they said that the tabulation process is not a public process because there's sensitive information of voters. Now, they're not saying, the tabulating of the results, but just getting to, even provisional ballots, there's sensitive information when we're looking up the information to present to you to verify voters' registration and address and things like that, that they're saying, some of the state election board members were saying that violates privacy by letting poll watchers be able to have access to that. But what it really boiled down to was just being able to give them more access to observe the tabulation process, to not really, they don't touch anything, they don't say anything, they just have more access in larger, it's really to do with larger counties, because if you have like Fulton County and it only says that the law says you can only have 2 poll watchers for all of the machines, in that one precinct, it's hard for 2 poll watchers to be able to observe and tell if things are being done right. I don't really feel like it affects our county whatsoever, but it was passed to initiate the rulemaking process on that one.
And then, let's see. There was something about protecting poll officers from threats of violence, but.
Yeah. It extends protections to election officials.
Yeah. And
I got this one.
Okay.
So House Bill 1312 is the bill that will have us do a statewide election in June of next year for Public Service Commission. And I spoke today with Representative Jaspers about this. And the Public Service Commission is the board that sets the power rates. There has always been a board for it, and because of courts, they have prohibited up until now to be able to have an election for this. I believe it might have even been something that was appointed, but new legislation changes that, and we will end up doing an election June 17th of next year. It will be a partisan election. We will have the primary for it June 17th. Possible runoff would be July 15th. And then we will have the election for it when we have the general municipal election November 4th of 2026. And that is just to stagger those positions, because once we have that election, then this race will fall into the timing of the governor's race and other statewide races, and the counties won't have the burden of having a statewide election every year that we have a municipal election. It will only be a one-time special election for next year. And it will be for a 6-year term.
And the governor signed this, correct?
Yes.
Because it said that it went into effect as soon as he signed, so. Okay. They were busy downtown, making you busy now at the office, ladies. Have at it.
And so the state election board meeting was today. It started at 9 o'clock this morning. I provided you with a copy of their agenda for the petitions that were heard today. There was one that was tabled, two that was passed to initiate rulemaking procedures, and 2 that was withdrawn. The petition from Marilyn Marks to go to paper ballots, that one was rejected, by the state election board. Marilyn Marks also had a second petition, involving recounts, and that petition was tabled until the next meeting, which is that August the 19th. She is stating that the code section, versus a state election board rule, they both say something different, so what she was trying to achieve was getting, one or the other to, one says that you do a recount with, the machines, one says that you do a hand recount. So they're kind of contradicting each other, so she would like them to, both say the same thing, that way, we have better guidance. But that one has been tabled. The tabulation observation access for poll watchers, that was passed to initiate rulemaking procedures and will be addressed at the August 19th meeting. The petition for voter challenges was withdrawn, and it was withdrawn by the petitioner. And they are going to work with the SEB chair to draw up verbiage that they can both agree on in order to be presented and passed at a future meeting. There was a petition to post how many people voted each day on your website or outside of your door, which we already do that with our summary report, but this would break it down even by precinct. And that was a petition that was passed, and they will be initiating the rulemaking procedures on it. And then there was also a petition for before certification for board members to have access to all documents from our office that we use to present you with certification results. You board members would have access to all of those documents before verify certification before they voted on it. But that petition was withdrawn. So that's where we were with what was heard today, and then we will to be continued and find out more come August the 19th.
So we still don't have the final decision on the one about them having to count
No,
at the end of the election night.
that is currently posted on the state election board website, and it will be heard, the petition will be heard on August the 19th.
Okay.
And at the meeting that we had last week, the new chair was there, and he said, he's like, I know not everyone can come to the meetings to do public comments, but he said, I read all emails. So if anyone has comments on any of the proposed rules, he said he reads all of them.
And I also included information from Gabrielle, which we are part of. That's the Georgia Association of Voter Registration and Election Officials. Gabrielle hired a lobbyist last year, and in response to some of these petitions that have came up, Gabrielle took a stance on these petitions, and I have included what they have submitted to the state elections board pertaining to each petition and the rule changes, so that's for you to be able to look at as well.
And going back to what you had mentioned, Karen, so I'm assuming it's the SEB public comments at sos.ga.gov that's on the bottom of this page for the new.
I don't know if he has his own separate you can send to.
Is this the state election board?
Send
If you go
comments.
to the state election board or to the Secretary of State's website and go under state election board, you can click on each one of the board members and it has their contact information.
Okay.
And then there is just also a general email that you can select, and it will send it to to the state election board.
So if there's anything that is still pending or rules that they're trying to, we want to comment
Yes,
or
if-
give input on or something.
If, I mean, not speaking on the board as a whole, but if you as a voter, feel passionate about any one of, the rules that are being,
Or even as experience as a poll worker.
being petitioned, then I urge you to reach out, and email these, state election board members, because the more of us that they hear from, the more insight they have, because most of them probably have never been poll workers or sat on an election board. So our input is crucial in then making these decisions.
And I think especially when it comes to items like having 3 poll workers manually count ballots after you've been working
When you-
all day.
When you start your day at 5:30 in the morning, and I appreciate every single one of our poll workers, but I mean, you could be expecting them to work.
And maybe it's something that you count later, but I think having them count at
That
the
night.
precinct that night when everyone's tired and they can't leave until it's all done, and make sure all 3 of them agree when they're all tired. It's unintentionally going to create problems that I think they don't realize.
And I think another concern that comes to mind for me too about something like that is if you have the manager and 2 assistant managers, that leaves 2 people to be putting away the equipment or doing some of the other duties, and that's not necessarily enough for all the tasks that have to be done to close down the precinct that at the end of the night either.
Yeah.
So you're just gonna extend the time frame that they could potentially have to be there. I mean, I'd really hate to have them work a 24-hour day.
Exactly.
I'm just
That's all.
logistically looking at that as like, that's a lot.
Well,
So-
the other thing that, that I think about is one, the burden that it's putting on our poll workers. I'm afraid we're gonna lose poll workers over it. And, 2, I completely 100% trust our poll workers. But I've got 12 precincts with 3 people at each precinct touching those ballots without me there to observe. I can't be but in one place at a time, and I don't like the thought of multiple people touching those ballots. And there will be poll watchers there to observe. But if something happens to any of those ballots, the Secretary of State's going to ask me, well, what happened to those ballots? And I'm not physically there to be able to attest to what happened to any of them. I feel like we have really good poll workers, and it would be done, properly, and everything would get back to me, packed and sealed the way that it should. But that's 12 locations, and then there's counties that have, 50 plus polling locations. I just don't think that the chain of custody, I feel like will be broken, with it worded the way that it is right now.
Alright.
So Stacy, you told us what happened on those matters. So all these other ones, those got carried over to August 19th?
So, you're talking about the investigation
I'm talking
reports?
about the other procedure matters continued. Item 5 on your agenda.
And that might be taken up tomorrow, that might start tomorrow, but like what I read to you today is just what we got through in one day.
I say, cause there's more,
Well, I don't know.
No, I think their next one's the 19th.
The 19th. I know he said during the meeting, he was like, if we don't get finished, we're gonna continue into tomorrow. But I had
Oh, it
this,
does say that on the bottom.
Yeah.
It says the meeting will be continued if they don't finish.
so that's as far as we got into the meeting today.
Oh, wow.
So
Did
if
you get
it's,
to the investigations?
those were dismissed.
I know that.
Yeah, all of those were dismissed. But
yeah, cause
The
there's
ones-
more listed back here than what they covered today,
Yeah,
so it's gonna
right.
roll into tomorrow.
Yeah.
Gotcha.
so that's just as far as we got. And then you can go to the Secretary of State's website, to State Elections Board, and you can, they have the video where you can go back and watch this if you would like. It will take up your entire day.
But if you want to forward past public comments, you'll be forwarding for a while.
Yes, and after the videos are posted, like about a couple days or even a week after it's posted, there is a summary report of the meeting. If you would rather read the summary report than watch
Are they
it.
still doing the transcripts?
Yes,
They'll do
I
a
followed the
transcript,
transcript today.
I think the transcript takes more like 30 days or something.
Yeah.
Gotcha. All right, well, I guess they're busy too. Making us
Well,
busy.
he was joking because he got appointed when he was at the meeting last week and introducing himself. He said, when the governor appointed me, they said it would just be an hour or two each week.
Oh,
But this,
Oh,
so when
Lordy.
you say the new chairman, he's been chairman for a while.
No, he's brand new.
No.
Oh, Brand, he just, so
Judge
the old guy?
Duffy, yeah, Judge Duffy resigned.
No, I know
Yeah.
that, but this new guy, he's been the chair for at least a few months. Oh,
Or
no.
at least a few months.
Oh,
a
yeah,
few months.
yeah. No, I knew Duffy
Yeah.
resigned,
Yeah.
but yeah, okay. Okay, I didn't.
Yeah, and then Matt Mashburn, he was the interim chair, but then he didn't get reappointed.
Right,
There's
so
like
now we have
two
a new
new
guy.
appointees, I think.
Yes, yes.
Yeah, okay.
All right, well, that was a rather lengthy and highly necessary, so we appreciate all the guidance on those. Next item on the agenda is staff comments. Stacy, anything else you need to share?
Jeannie and I are going to Cartersville tomorrow for a round table exercise that's hosted by the Secretary of State. Each region is gonna get together and participate as one on this training, and then we will be going the end of the month to Macon for state mandated training for a few days. So we're breaking Jenny in good. She's getting her certifications right now. She's doing that online, and she's I think she's learning a lot. She hasn't left us yet, so we're hopeful that she's gonna stay
If
after
you
all
make it
this.
through this.
I say we're not scaring you away, right?
Next year will be boring.
Yeah.
But staff, I mean, we're working on keeping the voter rolls updated in the office, and getting things filed as quickly as it comes in for new registration. We've had a lot of people come in to check their voter registration with the upcoming election. We've had a lot of people call, and then we've had several, people come in that have not registered before that wanted to register for this election. So the office has been busy.
Awesome. Thank you. All right, at this time, our next item is public comments. Do I have anyone that would like to share comments, concerns?
No comment.
No? All right, well, we appreciate y'all sitting through this. Hope you've gained some additional insight into the new things coming down from the state office. So, board comments. I will start over here with Ed and we'll work our way down. Ed, you have something, anything?
Just one quick question. There was something the Secretary of State's office said about deleting non-resident or illegal voters. I don't want to use the word illegal, that's not right. Voters that were not citizens, I think was how they said. And has that been initiated yet? Have you heard anything about that?
Well, if you register to vote, you go through a process to verify your citizenship, and if it cannot be verified, you go on a clock. But as far as I know, there's no. I know with Jarvis, it puts that clock as being the longest amount of time that they could put out there, so that they don't get deleted. They just, they don't become a registered voter until they provide the proper documentation to prove that they're a U.S. citizen.
Yeah, I just remember reading that and I haven't heard anything further about it.
Yeah, no, we don't delete anybody. If they can't be verified in the overnight process, then they go on that citizenship clock.
Thank you. Thank you for all y'all do. Welcome, Jenny, again. And keep at it. Gotta swim hard until December, bro.
Terry?
So I guess reiterate what Ed said, I really appreciate everything you guys do. I know it is a stressful job and it's not gonna get less stressful probably through the end of the year, so we really, really appreciate it. And welcome, and we're glad you're still here.
Rick?
I know, I appreciate everything that everybody's done so far. I know it's gonna be a busy, several months, and I look forward to the fun. Thank you very much, and I'm glad you're still here.
And you look forward to that, huh? Okay.
We're gonna have to drive faster.
I'll drive.
Becky, anything?
I have nothing. Thanks, guys.
And I will echo their comments. Thank y'all for sticking with everything. And Karen, I also appreciate you after a 5.5 hour day coming for a 3-hour board meeting, 2-hour, 2.5 hour board meeting.
When I left that one, I texted my boss to say, we just finished, and went back to the office. He said, no, I need you to come to this Board of Commissioners meeting. So I went straight to the Board of Commissioners.
Oh my goodness, you've had a day. You've had a day. But no, there's a lot of things that I know that y'all do behind the scenes as far as prepping for the meetings and keeping us on track and providing us with the most pertinent information that we need to help support you in doing what you do. So thank you all. Appreciate it. All right. Last item on the agenda. I'll entertain a motion for adjourning. Do I have a second?
Second.
Any further discussion? All those in favor? Meeting adjourned. Thank y'all very much.